So one thing I wanted to address, first of all, is to do with how property becomes vacant. And a familiar situation where a tenant's got into financial difficulty, they want to get out of their lease commitments, is they simply walk away from the property, shut the door, lock it, return the keys to the landlord or the managing agent. The hope being that the landlord will be careless enough to conduct itself in such a way that it's taken to have accepted a surrender of the lease. Now, there might be little or no hope of the tenant meeting its lease obligations. So why not accept a surrender? Well, there may be former tenants or guarantors, and so the landlord will want to keep them on the hook and therefore won't want to accept a surrender. Also, a surrender puts the landlord in the firing line for empty rates liability and all those other outgoings I just mentioned. So how do you avoid accepting a surrender? Well, it's not a very difficult trap, really, for a landlord to avoid. It's rather a desperate kind of ploy from a tenant. The key is that the landlord's conduct mustn't show any intention to treat the lease as having terminated. Now, that doesn't mean you have to send the keys back. It's usually a bad idea. You send the keys back to the tenant, they send them back to you, you send them back to them, and you get a kind of postal ping pong with keys going to and fro indefinitely, which is very, very bad for security, apart from anything else. What will be the terms of any lease? Again, we await regulations for some detail in relation to that. There is some content in the bill, so we know that the length of term will be between 1 and 5 years. The specified use will be whatever suitable high street use the local authority has identified. The premium payable or the rental payable must be in accordance with the bid which was made as part of the auction process, and the tenancy will be contracted out of the Landlord and Tenant Act 1954. But that's about it, really. The bill provides that in making regulations as to the terms of any tenancies, the Secretary of State must have regard to the terms on which short-term tenancies are typically granted on a commercial basis. We wonder how the Secretary of State will go about finding that out. You wonder also, whether there will be any regard had to the kind of standard forms which are freely available. The BPF short-term commercial lease, the RICS small business retail lease, the Law Society's short form model commercial lease. This could be an opportunity for government to impose, if not a standard form of lease, then at least an easily amendable template to keep transaction costs down. Nobody wants to be spending hundreds of pounds on lawyers, sadly, for these kind of short-term, low-value commercial lettings.